A common theme in the tax code is that on occasion, spouses or family members are treated as one owner for tax purposes. A question often arises as to whether that same presumption should carry over into the estate plan. So this is a presentation on estate tax valuation for attorneys and advisors who want to understand some of the estate tax issues that can arise when valuing property that might go into a trust such as a QTIP trust to preserve in a different form joint ownership after death. This might also apply for individuals who have estate plans which create a QTIP trust, and in situations where that QTIP trust may transfer assets that are subject to discounts such as business interests or real estate. I'm Griffin Bridgers, and this is 10 Minutes with Griffin. Today's episode 227, is all about estate tax valuation under the tax court case of Nowell versus Commissioner. We're also going to dig into Code Section 2044 briefly, which will hover in the background of the holding in Nowell. And I know for a lot of you who are lay listeners and aren't in the law, cases can seem boring or inapplicable, but this is a fascinating case to me, and I hope it'll be fascinating to you. As always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. And as a quick plug for myself, I enjoy speaking and teaching. I enjoy sharing my craft, so if you'd like an in-person or virtual speaker for your firm, organization, or event, please email me at griffin.bridgers@gmail.com. On to the presentation. So, the common scenario, as I briefly outlined at the beginning, is that some assets, like entity interests or fractional interests in real estate, might be subject to valuation discounts. And usually valuation discounts arise because there's two or more different owners of interests and the interest percent is below a certain threshold. Now, the discussion today is not necessarily about discounts. It's really more about determining the fractional ownership percent that might then be subsequently used to determine whether there is a discount. Now, the big question is what happens if the estate plan naturally creates this fractional ownership? Can the IRS argue that the fractional ownership is a fiction and should be ignored when it comes time to determine the value or even discounts? And even more, what might happen at the death of a survivor who's treated as the estate tax owner of two fractional interests that technically have two separate owners? Well, we'll dig into that a little bit, but to set the stage, we have to look at a timing, a temporal type of argument of when does valuation actually apply. Now, for some of you, this is common knowledge. For some of you, it's not, but I'm assuming you know that the value of property for estate tax purposes will be the fair market value at the time of the decedent's death or at the alternate valuation date. But there's a little more depth to that than is plainly stated in the law, is that really what you're doing is you're valuing the property as if the decedent were living on either valuation date. The value kicks in really immediately prior to death. So, for example, if you had a situation where a decedent owned 100% of property and then created fractional interests under an estate plan, you couldn't disaggregate the ownership based on the estate planning results to determine the value of each fractional interest. You'd have to value 100% of the interest or entity in the decedent's estate. So an example of this was the case of Amundsen Foundation versus U.S. This was a Supreme Court case where the decedent owned 100% of the stock of a corporation, 99 shares were non-voting, and 1 share was voting. So the decedent had all these shares, then created a plan that gave 99 non-voting shares to a charitable foundation and one voting share to non-charitable beneficiaries under the decedent's trust. And in that case, they tried to argue, the decedent's estate tried to argue that the 99 non-voting shares should be valued separately from the 1 voting share, but Ultimately, the Supreme Court held that that's not the case. They'd supported the lower court rulings that you had to value the stock based on the decedent's ownership of all 100 shares just before death. Now, that's in a situation where the decedent's estate plan itself has created the different fractional interests, but it might be the case that maybe a prior decedent has left property in a way that creates different ownership on paper, but the two separate ownership interests might be combined in the gross estate of somebody in question whose estate tax liability may be being assessed. The common example here would be a surviving spouse, where maybe the surviving spouse has an individually owned interest, maybe in their own name or in the name of a revocable trust for which they're treated as the owner. So that's its own separate issue, but then there's also maybe an interest that passed from a predeceased spouse into a trust such as a QTIP trust for the surviving spouse, which was eligible for the marital deduction due to a QTIP election. Now, the big picture here is that you have two separate owners, but both fractional interests would be included in the surviving spouse's gross estate. You'd have 2031, 2033, or 2038 applying for the individual ownership, and tax code section 2044 for the QTIP interest, because anything that's eligible for the marital deduction just defers estate tax until the surviving spouse's death. So, in the case of a QTIP trust, Code Section 2044 says whatever's in the QTIP trust is included in the surviving spouse's gross estate. Now, the tax court went to battle with the IRS in the case of Nowell versus Commissioner. It was a tax court memorandum opinion from 1999, which looked at this exact issue. And ultimately, the outcome and the holding here was that you couldn't aggregate these two interests together. So even though the spouse in question had to include both the individually owned interest and the QTIP interest in their gross estate for estate tax purposes, those interests still had to be valued separately and independently. You couldn't aggregate the ownership to value them together. And this is different from the Amundsen case that we just looked at, because in this case, Nowell, the fractional ownership already existed just prior to the surviving spouse's death here, and not because of the surviving spouse's own estate plan. Now, one bonus from the Nowell case was that it dug into the fact that there was an LLC or partnership agreement in place, and looks to the fact that sometimes there are restrictions on transfer and restrictions on admittance as a member of an LLC or as a partner of a partnership under the entity documents. So it might be the case that if there's a partnership interest transferred or an LLC interest transferred, the person who receives it only has the status of an assignee unless and until the other members or partners actually admit them as a member or partner of the entity itself. So because of that, there's usually only a right to receive income if you have an interest as an assignee. You don't have the right to vote or participate in the entity in any other way, shape, or form. So it seems intuitive then that the value of an assignee interest, regardless of the percent ownership, would be worth less than the value of an equivalent percent ownership interest where the owner had actually been admitted as a member of the LLC or a partner of the partnership. And that was also supported in the Nowell case. They dug into the fact that the partnership agreement in state law limited a person's status and economic interest to that of an assignee unless and until they are admitted as a partner. So that creates an opportunity for further valuation discounts, and I'll split hairs on that on the next slide, but I want to note here that this case, Nowell, happened in 1999. It's now 22 years later, and there's been an increasing trend that the IRS has started using an assumption that family members would act in concert when you're looking at an entity. So, nowadays, that could be used to try to defeat the argument that an assignee interest is eligible for a discount below the value of a regular partnership or LLC member's interest. especially when the members or partners who would vote to admit that assignee is a partner or member are also family members, because in that case it's assumed that admittance would be automatic, that everybody might act in concert to do so. Now that hasn't really popped up as precedent, but I could see that as a way that this could be defeated in the future. Now, there's a few closing points I want to make as to what's unstated in these cases, or in the context of these cases as we look at it. So Nowell really hinged at the end of the day on the fact that the economic ownership between individual ownership and a QTIP trust was different, because all a QTIP trust provides is a stream of income to a spouse. It's owned by a trustee who has its own separate and independent fiduciary duties, not just to the spouse but to other beneficiaries, whereas individual ownership is unrestricted. You can do whatever you want. So that's really the crux of why the tax court in Nowell said that you can't aggregate the ownership interests, because even though both interests are included in the spouse's gross estate, they're vastly different interests on paper in terms of economic benefits. But there might be scenarios where the IRS could argue for aggregation and win. So where might that arise? Well, I'm going to give you an example of maybe you have a child who dies owning both an individually owned interest and maybe an interest in trust, where maybe the trust is a fully discretionary trust and the child is a trustee. So why would that scenario be different? Because there would be no separate fiduciary duties in that case that would soften the economic interest there. Because in this case, the fact that the child is trustee, one, and has a fully discretionary interest, two, would create a general power of appointment, which would cause inclusion of that interest in the child's gross estate. So the child's gross estate would consist of both the individual interest and the interest that's included by virtue of a lifetime general power of appointment. So in that scenario, a lifetime general power of appointment for both tax purposes and creditor protection purposes and fiduciary duty purposes could be treated the same, one in the same, and they could be aggregated to really argue that there is individual ownership of the whole and not part and parcel. So in this case, state law could save you if, for example, there is a presumption under state law that there is an ascertainable standard under the trust if there's an interested trustee, unless the trust states otherwise. But that may not always be the case, so it helps to really dig into state law here and see how it might affect the outcome. I also want to remind everybody as my closing remark that these are not discounting cases. We're not arguing for the existence or non-existence of a discount. We're really looking at aggregation. So the question is whether or not percent ownership interests can be aggregated or not. Now, the outcome of that aggregation question may affect whether or not you're eligible for a discount, but before you can even determine whether or not you're eligible for a discount, you first have to answer that question of whether or not there is actually aggregation. And if you get nothing else from this discussion, that is the crux of the arguments in these various cases that we just looked at. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Once again, I remind you that I cannot give tax or legal advice, so please don't email me those types of questions. But thank you again for joining me for this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.